National Security Act, it came into force on the 1st of August 2016, which is why this conference is so timely. It was rushed through Parliament and effectively gives the Prime Minister power to declare a security area which becomes a legal black hole. Now the rush through Parliament, members of Parliament are here. I see YB Nurul Izzah and YB Zuraida. You remember the night that you had to debate this bill, right past midnight, I think it was, or very, very late into the night. And what I recall is how the Taknak Dictator Coalition went to Parliament to try and persuade our members of Parliament why this bill, which they were trying to rush through, I think opposition just got it 48 hours before it was presented in Parliament. And so we were trying to tell them, look, just wait, please allow for more discussion. Sorry, YB Teresa is here as well. Please allow for more discussion. That's all we were asking for. But they absolutely flat refused to give us any further time to debate this very, very oppressive bill more completely. In fact, we were quite horrified to see how many of our members of Parliament did not, in fact, had not even read the bill. They didn't even know what the provisions said. They didn't know what they were. They knew not what they did. Let's just put it that way. They knew not, many of them. So this is the key section in the National Security Act. What we have is, and if you look at this part, it says where the council advises the Prime Minister. So there is a council which is purely advisory in nature, advises the Prime Minister, and that the security in any area is seriously disturbed or threatened by any person, matter or thing, etc., causing harm to the economy, national key infrastructure, and these are really frightening words, or any other interest of Malaysia. That is about as wide as you can get. We don't know what that means, and we don't know how it will be used. Now, I know many people might, hearing us for the first time, might feel we are paranoid. Now, why are you so paranoid about loose language in legislation like this? We're paranoid because we know how it can be abused. Because we know that legislation like this has been abused in the past. So, key here is, it's the Prime Minister who makes the decision. And it is the Prime Minister may, if he considers it to be necessary, despite the advice of the Council. So, what then is basically, oh sorry, I've gone backwards. Right. Now, one of the objections to the National Security Council Act is that it offends the Federal Constitution. Under the Federal Constitution, we have Article 150, which provides for the young Lipunan Augong, if he is satisfied that a grave emergency exists, whereby the security or economic life or public order is threatened, he may issue a proclamation of emergency. So under the Federal Constitution, the powers to declare or proclaim an emergency vests in the young Lipunan Augong. So as far as we can see, and that was the first thing we said, this National Security Council Act is unconstitutional. Now, what is the answer to that? Oh, ours is security area. There, it's talking about emergency. It's the same thing. It's just calling it by a different name to give an impression that it doesn't impinge on the Federal Constitution. Which is why the rulers objected. The rulers in council, in fact, on the 17th of February, returned the National Security Council bill to the Attorney General's chambers seeking a refinement. Attorney General Apandi Ali then said he would review some sections of the bill, while Prime Minister Najib Abdul Razak said he took note of the rulers' suggestion. Nevertheless, the NSC bill gazetted as law was despite the ruler's call for a refinement. As far as we can see, no changes were made. So we don't know what the refinement is, we don't know what they took into account, we don't know, of course, what the concerns were that were raised by the rulers. It's a pity. In fact, parliamentarians should have been briefed. about the concerns of the rulers. I don't know, Isa and Teresa, whether any of you got any notification about why the rulers were unhappy with the bill. They didn't bother. So nothing happened, nothing moved. So therefore, Putrajaya's new security law was gazetted without royal assent. That is pretty unprecedented, because what it means is the king refused to sign, refused to give the royal assent. There is a provision under the federal constitution where after 30 days of the failure of assent by His Majesty, the bill goes into effect nevertheless. And that is what happened in this case. So obviously the rulers took an interest because it impinged very much on Article 150 and the powers of the Yang di-Pertuan Agong to declare an emergency. Of course, the NSC, we say, usurps the power of the Duly Yang Manggurya, the Yang di-Pertuan Agong, which will now be exercised by the Prime Minister, even though the word emergency is not used. Now, the king, of course, is a constitutional monarch, but there are certain powers there, certain discretions that are in the federal constitution. When it requires the king to declare an emergency, there is a check and balance. That check and balance is completely removed when the Prime Minister vests in himself absolute power to declare a security area. Now, interestingly, if you all recall, and I think people like Human Rights Watch, Phil, etc., will remember when the Internal Security Act in Malaysia was abolished, there was a huge celebration. We thought this Prime Minister, and it is this present Prime Minister, who brought that about. He abolished the Internal Security Act, and everyone rejoiced. We thought that was the end of detention without trial. That was far from reality. Now, this is a section, interestingly, that was in the repealed Internal Security Act. And if you look at this, it involves the Yang di-Pertuan Agong. So a proclamation of security area, so they use the same word, security area, if in the opinion of the Yang di-Pertuan Agong, public security in any area. So it vests in the Yang di-Pertuan Agong to actually declare, make a proclamation that there's a security area. So that was in the repealed ISA. What else was in the repealed ISA? These words, where the security is seriously disturbed or threatened by any substantial body of persons and a substantial number of citizens to fear organized violence against persons or property. So you get the drift that this Internal Security Act and this particular declaration of security areas in relation to a huge upheaval of sorts, which involves a large body of people. So that was the repeal of 47. So now let's, if you recall the section 18, how do you compare the NSC with the ISA? The NSC, the declaration is by the Prime Minister. Under the repealed ISA, it was by the King. Under the NSC, the words used are seriously disturbed or threatened serious harm to the people, etc. All those nebulous words or any other interest of Malaysia. Whereas under the repealed ISA, the words are serious threat by a substantial body of persons to a substantial number of citizens to fear organized violence. So, what have they done with the NSC? They have revived the Internal Security Act and made it worse. So it is a very bad version of the Internal Security Act. Now, how do we see the Internal Security Act? This is the summary where we are concerned as civil society. It is a threat to parliamentary democracy, and I will explain that in a minute. It allows the concentration of extraordinary powers within the hands of a single member of the executive arm of government. It has the mechanisms of checks and balances normally found within parliamentary democracies are absent, and the NSC bill represents a quantum leap towards a dictatorship and a military police state. So That is the summary, that is our stand from civil society. Now look at 18.2. 18.2 says basically that a declaration of security area shall cease to have effect upon the period specified, which is basically 6 months. And then it lapses. But then look at this. Notwithstanding that section, a declaration in force may be renewed by the Prime Minister from time to time for such period not exceeding 6 months at a time as may be specified in the declaration. So they put in what looks like a safeguard and immediately take it away in the next section. So what this means is the Prime Minister can go on and on and on declaring, extending the declaration for as long as he sees fit. Does it say anything about the advice of the Council? No. He does not have to consult the Council. Then we have 18.6. They say, we have Parliament to oversee. Well, those are the words. All it says is, a declaration shall be published in the Gazette and laid before Parliament as soon as possible. So whenever they want. They just lay it before Parliament, there's no debate, no nothing. How is that oversight by Parliament? Now here's one of the reasons we say that there's a terrible undermining of parliamentary democracy in the way in which this Act has been drafted. Now, Section 17. Here you have, what it does is it has the power under Section 17 to compel government entities to report to it and furnish information. It allows the NSC to override a state government's authority. So in other words, it becomes a super intelligence gathering entity, very frightening for everyone. So those checks and balances are lost as well. You can do a lot with intelligence. Now, power to control movement. These are the kinds of powers we're talking about, which is what concerns us very much. They can control movement of any person, vehicle, vessel, aircraft coming in and out of the security area. They have power of arrest without warrant. Any person found committing, alleged to have committed, or reasonably suspected of having committed any offense. Now that's very wide again. So without warrant, they can do this. They have power to seizure and sale, also without seizure and search, also without a warrant. And then you have 33. They can order destruction of certain unoccupied buildings. I'm just giving you some of examples. This is the section we call the license to kill. They can use reasonable and necessary force. Look at the words. As is reasonable and necessary in the circumstances, the use of such force against a person shall not include anything likely to cause death or GBH to the person unless, and then you always have the unless, you see. These words look very reasonable, then you get the unless. The member of the security forces believe on reasonable grounds that doing such action is deemed necessary. Again, very nebulous language. Section 35, power to dispense with inquest. This is another very frightening provision. A magistrate can actually, where he is satisfied that the person has been killed in the security area as a result of operations undertaken by security forces for the purpose of enforcing any written laws, the magistrate or coroner, as the case may be, may dispense with the holding of a death inquiry or inquest on the body of the person. This includes the security forces as well, by the way. Now then you have a section 37 and 38. It provides for obligations of secrecy and it provides for protection against civil suits if things are done in good faith. So everything is clouded and shrouded, shrouded in secrecy, which is why we call it a legal black hole. Now, one of the things, and you would have heard that this morning, is we have so many other legislation which is purportedly used for the prevention of terrorism. One is, and you know, this was addressed by the speaker this morning, Prevention of Terrorism Act. We also have the Security Offences Special Measures Act 2012. an act to provide for special measures relating to security offences. And we have also, of course, there's a liberal use of other legislation. There are sections in the penal code relating to terrorism as well. So how many levels of protection are you looking for? That's really our issue. Now, I said to you earlier that we are very concerned about abuse, and we have good reason to be. SOSMA was used recently against Matthias Chung and Khairuddin and the charge against them was something to do with the economic sabotage of the economy. And they were thrown behind bars. I think they were in prison for a month before they were brought to court, etc., etc. Now, that's the kind of abuse we're talking about. Matthias Chung was the lawyer to Dato' Khairuddin. So there's an attack on the legal profession there as well. That's the kind of abuse we are getting used to now. That's why we're paranoid. We have very good reason to be paranoid about widely worded legislation like the NSC, which has absolutely huge repercussions, can have huge repercussions. Now, this is the case of Tay Cheng Ho, which talked about the Internal Security Act. This is the bit I wanted to just point out to you. This is about the powers of the Supreme Head of the Federation, the Agong. Basically, that he's a constitutional monarch, and except on certain matters does not concern the instant appeal, he does not exercise any of his functions under the Constitution on his own initiative, but is required by Article 41 to act in accordance with the advice of the Cabinet. Now, this is why I have this question. Why was Parliament and the Cabinet so ready to give away all its powers to one man? I could never understand that. Partly, they didn't realize they were doing it, because you need to read the Act before you realize that was happening. And to me, it was reckless. It was a completely reckless move by Parliament. Of course, save for the opposition MPs, I'm talking about those in government, completely reckless. And I know that because a few of us went there, and you recall when we tried to speak to the parliamentarians, they took our memos and didn't do very much about it, basically. They just went ahead and voted. Same with the Senate. They said a few things, but when it came to putting up their hands, they voted for the bill. I understand the whip system, but they have stopped legislation before they have asked the government to hold back when they felt certain changes needed to be made. And quite horrifying for us to realize that, in fact, they were prepared to even ignore the ruler's request for a review. So this is the Reid Commission. They're the drafters of our Constitution. What they said was, we recommend that the Constitution should authorize the use of emergency powers by the Federation, but that the occasions on which, and so far as possible, the extent to which such powers can be used should be limited and defined. So they were always very aware that emergency-type legislation, or emergency-type, the provisions under the Constitution, give awesome powers to the state. And they suspend ordinary laws. You've heard what Daud said this morning. It's frightening, actually. What they are allowing to happen is bringing in military to resolve a civil solution. And I'm proud of our military, actually, that they are not interested in getting involved in the civil arena. And we need to keep it that way. We don't want to become a country that, we don't want to open a door for the military to get involved in civilian affairs. But I am very concerned that that is what is happening here. And as Daud has pointed out, a lot of it is illegal. They need to act within the framework of the Constitution, the laws that we have. Of course, there is no judicial oversight, unlike the Patriot Act. Now, this is something this is the latest that we have discovered. I'm not sure of any changes. But there's some form of judicial oversight in other countries under the Patriot Act. I don't know if there are any changes to that. But here, there's absolutely no avenue for judicial oversight in relation to the National Security Act. So in conclusion, basically what we're saying is, these are objections to the Act. For me, actually, it's not a question of amending the Act. We must repeal this Act. We must repeal it in totality, because the National Security Council was not set up for this purpose. It has other purposes, yes, not this. So this is what we would say: the constitutionality of the Act is in question. There are issues of the military chain of command, which Dowd referred to earlier. It gives unlimited power to the Prime Minister. From what I've shown you, you see that they pretend to have safeguards, but immediately you see in the next section or somewhere there that in fact those safeguards are illusory. They don't exist. Vague wording. You have arbitrary powers being given to the authorities, and the NSC will be a super intelligence gathering entity. So these are some of the concerns, and I think there are obviously many, many more. We don't know how this is going to be used. Let me tell you, it can be used in the next verse. Okay? It can be used to stop an election, a general election. You want to take it to its extreme. The whole country can be declared a security area. They don't like the Penang government, they can declare Penang a security area. This legislation is in the hands of a very irresponsible government. They have shown themselves to be irresponsible, and I'm only going on evidence. I speak on the evidence I have seen in the last few years. I have no confidence that this legislation will be in fact used responsibly for the purposes for which they say they need it. We are not unaware, and I am not for 1 minute underplaying the importance of security. We are in fact more worried about security than the government. They have bodyguards, we don't. Ordinary people are always afraid of security. So to say that we are not concerned is very naughty, actually, very irresponsible. We are very concerned about security. What we're saying here is, you've got enough. You've got enough to deal with the security issue. And I want to end with this. Sydney said it beautifully this morning. You want to talk about extremism in the country, and this is where it's homegrown. It happens when we have massive corruption, which we have in this country. It happens when there is authoritarianism. That's authoritarianism. That absolutely crowns it. It was already present, but this is a gift to the Prime Minister to be authoritarian. So for me, all we have done with this act is not reduce the possibility of terrorism. I think we have just opened the door to more possibilities of terrorism.